Good afternoon, everyone, from wherever you are joining us. Um, my apologies on our video. We're having a bit of a technicality, so I'm not able to play it, but I'll play it again towards the end. My sincere apologies for that. Welcome to the Commonwealth Businesswomen Network in Kenya's weekly webinar that we host every Wednesday. Sorry, is there noise in my background by any chance, Rose?
No, it sounds
Okay,
fine on your part.
okay,
I
okay.
know, yeah, internet is pretty unstable in many
Yes,
places this
yes,
week.
it is.
Mm,
Yes. All
keep
right.
going.
So welcome to our weekly webinars. We host this every Wednesday from 1 p.m. to 2 p.m. And we're very, very delighted to have you all here. So as per our norm, we are going to start off with a quick word of prayer. Let's bow our heads. Our dear Heavenly Father, we thank you for your promises, for beautiful days, for blessings at all times. And we thank you for this day. We thank you that we're able to be assembled here, and for all the people who are able to join us. We thank you for them and also for our guests this afternoon. We ask you for your presence. We ask you for your guidance and your blessings as we start our session. Please inspire our thoughts and our discussions and all our ideas as we continue to grow and flourish in our businesses as well as our personal lives. And we pray all this trusting and believing in Jesus Christ our Lord. Amen.
Amen.
Amen. Yes. Sorry, just excuse me for a minute. Sorry about that. Um, Sorry, it's just my issue with the video. I was really hoping to play it, but you'll enjoy it later. So yes, so this is the Commonwealth Businesswomen Network in Kenya, where we have these trainings every Wednesday. And our idea is to be able to impact our members as much as possible with the type of knowledge that they need for their businesses. And right now, especially when it comes to be compliant to the rules and the regulations of this country, this is very, very critical to us. Last week, I don't know if all of you were there for the session, we had an expert from the Kenya Revenue Authority who talked to us about the digital service tax, which is quite crucial to all the members who have businesses and they transact online. So we're able to learn a lot about, what we need to do, when the taxes are due, what is the scope of that tax. So that was really, really powerful. So today, once again, we continue to bring an expert who's going to talk to us more again about being compliant. And in this case, we are looking at some of the laws that have been passed and some of the proposals in place, especially when it comes to the Employment Act. Our title this afternoon is Employment Act 2021, the implications on your business. This particular amendment was signed on the 30th of March, which is this year, and it became effective on the 15th of April. So our guest is going to tell us a little more about that and also tell us some of the proposals that are in place, because there's been a lot of confusion out there on some of the content from some of the proposals. People keep saying that they've been passed, but they haven't. So she's going to clarify to us on that because it also affects our businesses. So it's going to be a very, very critical discussion. But before we get to hear all about that, as I mentioned, this is hosted by the Commonwealth Businesswomen Network in Kenya. And to tell us a bit about the organization and also to give the welcome remarks, I would like to invite Rose Nginja, who's going to do so on behalf of our chairperson, Nana Wanjao, who was not able to join us this afternoon. Karibu sana, Rose.
Thank you very much, Susan, for that kind brief. And I'll just ask all present today to really bear with us. There's a lot of unsteady network power cuts in Nairobi at the moment, but we just pray that it doesn't affect us too badly. So I'll just tell you a word or two on Commonwealth Businesswomen Network. the Commonwealth Business Women Network Kenya, CBWNK, is a ground partner of the Commonwealth Business Women Network. Commonwealth CBWN is a registered community interest company in the United Kingdom. CBWN is an accredited organization directly recognized by 54 governments across 6 continents to advancing UN Sustainable Development Goal 5 and the Commonwealth Charter. CBWN is focused on women's leadership, economic empowerment. We have a mandate to network over 1 billion women in the Commonwealth for the sole purpose of connecting, collaborating, and doing e-commerce. Not only e-commerce, but commerce as well. We've had sessions on e-commerce recently, and that has stuck into my head. So we collaborate, we connect the 1 billion women to collaborate and do commerce. CBWN mission is to strengthen the Commonwealth, build businesses, and advance women through our 3 T's. What are these 3 T's? They're talent, training, and trade. Through our 3 T's, we encourage, enable, and embed women's economic empowerment. So as Susan has indicated, we have various programs that run throughout the year, and this training is one of our key ones. As you have seen, it falls into the 3 T's. We have got other programs to develop talent, to identify and develop talent, and also to enable women to carry out business with their partners globally. So with that, we are aware of all the mandatory things that one needs to do. We carry out different programs for that. And today we are really glad to have someone to take us through part of the employment law, which is critical for this commerce to be able to take place. So over back to you, Susan, to take us through the next steps and introduce us to our guest today. Thank you. Susan, you're muted.
My mouth is not moving, nothing is coming out. Yes, sorry. Thank you so much, Rose, for those welcome remarks, and also on a reminder of what the Commonwealth Business Women Network really is about. So moving on, just a quick reminder to all the participants on Zoom, please remember to keep your devices on mute, especially when the presentation is going on, just to prevent any interruptions. And as we continue with the presentations, if you have any kind of questions or comments on Zoom, you can post on the chat box. And if you've joined us on Facebook, just post your questions on the comment section and we'll go through them after the presentation. Now, I feel quite honored to be introducing our guest this afternoon. So allow me to tell you a little bit about her before we jump into the discussion. Her name is Sarah Kangari, and she is an HR specialist. She's highly skilled and very, very experienced with over 16 years of experience. She has significant expertise in the core HR functions, such as the recruitment, the selection, the talent management, the performance contracting and management, learning, growth, industrial relations, and also the welfare of the staff members. She is astute in developing, in cascading, in monitoring and evaluating the organization's strategic plans and policies. Her other significant skills and competencies include communication and coordination of the programs within organizations, understanding a project delivery and acceptance processes, as well as managing teams and making recommendations for optimum results. So Sarah holds a master's degree in human resource management, as well as a Bachelor of Commerce in marketing, both from the Murdoch University in Australia. She is a certified system application product holder and also human capital management consultant and a member of the Institute of Human Resource Management. And last but not least, she holds multiple certificates in leadership and management. So yes, as you can see, she is very, very well versed where human resource is concerned, and she is the perfect person to tell us more about these amendments and all these proposals that are going to affect our businesses and our relationships with our employees or employers. So karibu sana, Sarah Kangari.
Wow, Susan, thank you so much for such a gracious introduction. I am equally honored. And before we even begin, I want to commend the Commonwealth Business Network for all the work that you're doing. Anything to support women to grow, to facilitate economic growth, women empowerment, employment is all very welcomed. So I commend all of you. And we can jump into it. Let me try and start sharing. Share screen. Are you able to see the PowerPoint?
Yes, we can.
Yes, we can. All right. So we can begin the presentation.
Yes, please.
So good afternoon. Like I was introduced, I'm Sarah Kangari. Today we are going to go through the Employment Amended Act of 2021 and its implications on your business. So let us begin. At the end of this session, I would like you to have gained an understanding of what labor laws seek to address, the labor laws in Kenya, whom the Employment Act of 2007 is applicable to, the major areas addressed in the Act, the impact to business arising from the amendments, and the further proposals that are still awaiting ascension. And feel free to stop me at any time. I have been given my time restriction and I will do my best to fit in there. So we begin. I thought before we jump into the Employment Act and the amendments to it, we need to take a look back of how did we get here? How did we get to the point of needing legislation to cover labor? And it's important for us to understand so that when we look at the amendments, we can confirm that indeed what is being proposed is addressing the problem that the laws are trying to cure. So the first thing that made us feel collectively as human beings we need to legislate labor was slavery. And I won't go into too many details on that because I'm sure we've all watched movies or read books or had accounts of slavery, whether it is in West Africa, in the States, in Zanzibar. We all know the working conditions, living conditions were atrocious. These humans were not treated humanely. In fact, in many cases, animals were actually treated better than human beings. So that began the first collective conscience, but particularly when slavery ended, for us as humans saying, maybe there's something wrong going on here that we need to address. Next is the issue of child labor, which unfortunately, unlike slavery, is still quite rampant in the world. And we've all seen, and I hope none of us are guilty of engaging underage house helps in our home, but in the farms, even in the Kenyan countryside, you've seen small children picking coffee, milking cows, picking tea. And it's an issue because when you engage in child labor, you deny this child a future because you've pulled them out of school. So you've curtailed and essentially really made them a slave. So because of that, we've said, no, we need to govern this. Next came the Industrial Revolution. So for that, we go back to the States. And this is when the American dream came into being, It was it's the land of the free, work hard, make money. And indeed, a lot of money was made. In fact, a lot of the billionaires who are still, in the 1% of the world's wealthiest came arising from the Industrial Revolution. So there are people who made a lot of money. But the employees who were engaged to build this wealth for the employer were poor. They were just a step above slaves. Terrible working conditions, terrible working hours. So all of those three things, the slavery, the child labor, and the industrial revolution, highlighted the imbalance of power between employers and employees. So that was broken through the creation of labor laws. Labor laws seek to address three main things. The first is to protect the fundamental rights of employees, which prior to this had always been ignored. Number two is to provide basic conditions of employment. Number three, to regulate the employment of children. Those are the three very broad areas that the laws seek to address. So we open the curtain and step into Kenya. What are the labor laws in Kenya? And these, much as the presentation is going to largely dwell on the Employment Act, it's important for you as business people, potential business people, or even employees in larger organizations to be aware of the larger legal framework that governs labor laws and how these laws interact with the Employment Act. Because we all know in law, ignorance is not a defense. So we go. So like I've said, labor laws are the body of laws that govern the employer-employee relationship and prescribe the standards to be observed by the employer and the employees. In Kenya, the supreme law of the land, as we all know, is the Constitution of Kenya 2010, which was promulgated in 2010. The Constitution highlights specific articles, which as business owners or business women, you will need to familiarize yourself as they address labor laws. The first one will be Article 27, which is freedom from discrimination. The next one is Article 30, which is the anti-slavery article. Then we've got Article 41, which defines what constitutes fair labor practices. So I begin with the Constitution of Kenya because that is the supreme law of the land. Next comes the Employment Act, and I will just jump over that because we are going to be going into it with more details. We look at the third one, which is the Labor Institutions Act of 2007. This established the labor institutions and provides for their functions, powers, and duties. So these are institutions such as labor offices. And for you may have encountered labor disputes, particularly this is in the agricultural sector. The first point of contact would be to the labor office. We've got wage councils, and we've got employment agencies. In case any of you are recruitment agencies, business owners, the Labor Institution Act is what you need to be familiar with. Next, we've got the Employment and Labor Relations Act of 2011. This act came about following the promulgation of the Constitution in 2010, and it established the Employment and Labor Relations Court, which hears and determines disputes related to employment and labor relations. So for you in your businesses, when you have a dispute and you have tried to mediate and all other means of bringing the matter to a conclusion and have failed, you end up in the Employment and Labor Relations Court. This is a very high-level court. It has the same status as the High Court of Kenya. So if you find yourself here, just know you are swimming in very deep waters. Next, we have got the Work Injury Benefits Act, WIBA, as you probably know. This is the one that determines compensation to employees when they get injured or catch a disease while in the working environment. And finally, we have the Occupation Safety and Health Act. Again, this is about the safe standards, because remember before when we talked about slavery and the Industrial Revolution, no standards at all. Safety did not matter. But now if you go to any construction site, you will see people with hard hats. When you go to hospitals, you'll see the gloves, the masks that the doctors and the nurses are wearing. This all falls under the Occupation Safety and Health Act. So I thought it would be important for you to understand the broader framework with which we operate in that governs labor laws before we start narrowing down. Now, before we go into it fully, we need to ask ourselves a question. And you as business people would need to answer this question, which is, who does the Employment Act of 2007 and its amendments apply to? Because you may go through this whole presentation and realize, oh, none of this was actually applicable to my business. or you've been thinking it's not applicable, yet it is fully applicable. So there are two tests that you'd need to go through to determine whether the Employment Act is applicable to your business or not. The first one is, are the individuals engaged in your business there through a contract for service? A contract for service is when you engage an individual for a specified time to do a particular activity, and usually you will pay them a fee. So these are consultants, anybody that is paid a fee. And anybody in your business that falls under that category is not subject to the provisions of the Employment Act. In fact, you'd need to look at the contract law or something else to see how they are governed. So if in your business you have got consultants that run it, Employment Act will not apply largely. However, the other side is contract of service. So a contract of service is defined by a number of things. One, this person is paid a wage, not a fee. And the wage is paid in predictable intervals. So whether it is fortnightly or monthly, usually in Kenya it's monthly, it is predetermined. Two, this person is engaged for at least 3 months or more. There's a contract in writing which stipulates what is going to be paid, where they are going to be working, what their job description is, and the requirements on their part. If you've got individuals in your business who fall under that category, then they are working under a contract of service, and therefore everything in the Employment Act and the amendments is going to apply. So if you fit there, sit up, pay attention as we get into it. So let's remind ourselves, excuse me, let's remind ourselves on the provisions of the Employment Act, first of all, before we look at what was amended. So the Employment Act is the supreme law when it comes to issues, employment and labor relations. And as business owners, if you have a contract of service, you need to familiarize yourself with all provisions of the Act. It is the primary legislation governing all aspects of employment, and it's the contents of the Act are very heavily geared towards protection of the employee, not so much the employer. And it does this by limiting the power of the employer by providing for the rights and duties in employment. It prescribes aspects like basic minimum working conditions, hours of work, rest days, types of leave that employees are related to, provisions for housing, for water, for food, medical attention, termination, dismissal. Basically, the Act governs everything from how to engage an employee, what to do with them while they're in your service, and how to terminate that relationship. Everything is covered there, so please familiarize yourself with the contents. Next, you remember one of the main objectives of labor law is to stop slavery. So the Act is very clear. It prohibits forced labor. So anybody under your service must be there willingly. It also promotes equality of opportunity in employment. So this is all of our anti-discrimination. We don't look at sex, age, ethnicity, height, color, whatever parameter that is superficial that you wish to bring and introduce as a point of discrimination is not allowed. Yes. Next, equality in remuneration of work of equal value. This is really important, and from the businesses and organizations that I've interacted with, unfortunately, what comes out is quite a number of businesses don't know the worth of each job. And therefore, you will find that the remuneration awarded to a particular job is almost whimsical, particularly for the SMEs. So I would encourage people, to encourage you business women, whether you have got a small business or a huge business, please routinely carry out job evaluation exercises to determine the worth of a job, which then informs the pay, so that nobody will go and say they were paid less versus the value of their job. Job evaluation is important. Next, the Employment Act regulates the wages to be paid. Currently, the minimum is slightly over 13,000. So all of us, our domestic workers and shamba boys and all, let's make sure we are paying them the minimum wage at least, because the wage is about dignity. It's about enabling an employee to live a comfortable life, at least a life that is within the socially accepted parameters. So let us observe the minimum wage. It also addresses issues of sexual harassment. And, you know, like in the States with this issue of Me Too, it's only in Kenya we would probably have a Me Too, but people are too scared to talk about such issues. But the Employment Act hibernate yourself when it comes to sexual harassment in the act. And since we are women and these are businesses, let us work to have an environment that is sexual harassment free, because unfortunately, though now it's changing, women bear the brunt of that. So the act defines what sexual harassment is and gives the provisions for how to handle it. It also requires, if your business has got 20 or more people, you need a sexual harassment policy. So if you don't have one, you need to get cracking. And actually, one of the proposed amendments is to bring that down to 5. If you have a business with 5 people, you need a sexual harassment policy. Next, the Employment Act supports, this is actually the most important aim of the Act, is to support the economy by facilitating industrial harmony. Remember, we said it's bringing a balance of power between employer and employee. We want stable working environments. We want heightened productivity. What we don't want to see is strikes, is industrial disharmony. We don't want to see any of that. And if we follow the provisions of the Employment Act, to a large extent, it has addressed the major areas of contention and given the framework within which employers need to behave or need to conduct themselves. And finally, in the event that you have put everything in place in your business to comply to this Employment Act and you still have a dispute, this Employment Act facilitates the resolution of labor or industrial disputes. We also have the Labor and Employment Court, which is the final and ultimate mediator on all things, all disputes related to labor and industrial issues. So that is just a quick recap of what the Employment Act covers and the major highlights that will applicable to your business. So now we get into the meat of the presentation, which is the Employment Amendment Act of 2021. As Susan said in her opening remarks, it's an act of parliament to amend the Employment Act for connected purposes. It was assented to on 30th March 2021. It commenced in 15th April 2021. So we are now almost 1 month into implementation of the act, of the amendments. So what exactly was amended is the question, and how is it going to affect your business? Section 29 of the 2007 Employment Act deals with issues related to maternity leave. Section 29 has been amended to include Section 29A, which provides for pre-adoptive leave for female employees. It entitles them to 1 month leave from the date the adopted child is placed in their permanent custody. They get the 1 month leave. It also requires the employee to inform the employer of their intention to proceed on pre-adoptive leave at least 7 days prior to proceeding on that leave. So that is the major amendment that has been made. That was supported by them stating that subsection 2, 3, and 7 of section 29 with necessary modifications shall apply to an employee eligible for leave under this section. So what is section 2, 3, and 7 and how does it apply? So section 2 of subsection 2 of section 29 states that when a woman returns from maternity leave, she's going to be entitled to take up the position she held prior to proceeding on maternity leave or a similar one. By saying it's going to apply, they mean that when an employee comes back from pre-adoptive leave, they are going to be entitled to retain the position, to go back to the position they held prior to proceeding on the leave, or be offered an equivalent one. Subsection 3 provides for a woman to be able to extend her maternity leave, or in this case, to extend the pre-adoptive leave, but there are some conditions. One, the employer must have consented to this, or it should have been informed by something else. So for example, sick off, they fall sick in the period of that adoptive leave. So this subsection 3 says that the pre-adoptive leave in this case will be extended up to the point which this extension has come to pass. So it may not just be 1 month. If the woman now gets 2 weeks sick off, it moves to 6 weeks. And it's at the end of the 6th week that the adoptive leave is now over. Subsection 7 prohibits states that a female employee is not going to forfeit her annual leave because she proceeded on maternity leave, which means in this case, female employees in your organization who opt to adopt and proceed on the pre-adoptive leave are not going to be required. In fact, you are prohibited from stopping them from enjoying their usual annual leave. So what are the likely impacts to your business? One, in terms of administration, you need to review all your HR policies governing maternity leave to now include a provision for pre-adoptive leave and the entitlement of that of 3 months. In addition to this, how the leave is applied for in your respective business. So if you use manual forms, you're going to either need to come up with a new form or amend an existing form to give a provision for pre-adoptive leave. If you are using a system, a digital system, you'll need to do some system configurations to now include this new provision of pre-adoptive leave. So that's in terms of administration. Now, you also need to sensitize your employees on the provisions of Section 29A. Remember, we said this amendment is live as we speak. It's almost a month old. So you would need to carry out a sensitization exercise, letting all of your staff know that it has been assented to, what the provisions are, what the requirements are from the employer as well as the employee. So like I said, for the employee, the requirements on their side is they notify the employer of the intention of proceeding on pre-adoptive leave at least 7 days before proceeding on that leave. And that number 2, they need to furnish the employer with some sort of documentation so that they can know that the adoption has happened. This is usually in the form of a court order or a court ruling that awards the child to that particular parent. So you need to sensitize your employees on what is expected on them and what the law provides. Now, another thing that you need to think of is the age profile of mothers in your organization, because I don't know if I should say traditionally, but it has been the norm that in employment, productive years for women is 22 to 40, and with some medical intervention, you could probably get to 45. And these are the reproductively active female employees. But now with the introduction of this amendment, it means your employees up to the age of 60 are eligible for going for maternity leave, so to speak. So you need to start thinking, how many do you have in this category? What impact are they going to have on the work plans for their respective areas? Remember, I said they're entitled to 30 days maternity, pre-adoptive leave. So when this person proceeds on that leave, and if they're the age of 55, this is either the owner of the business or a fairly highly ranked individual, what continuity plans do you have in place? Who is taking over those roles? Who is working on, all of this? Because your business needs to continue as this person has proceeded. So you need to think of that. And also remember that these are likely going to be very senior people in your businesses, as opposed to the traditional 22 to 35 or 40-year-old who is usually entry or middle level in an organization. So you need to think about how you're going to reorganize your work schedules. So that is what has actually been assented to and amended, and the impact it's going to have on your business in terms of administration, in terms of system, in terms of finances. So you need to think about it in all those areas. But that's just one thing. There are over 60 proposed amendments to this bill that are currently being debated. And I think we would need a week to go through all of them. But for your ease in the PowerPoint presentation, if you look at the screen, just the bubble just under, I have indicated the sections across the board that have been amended or are proposed to be amended. So please do go read them for yourself, familiarize yourself with them. And since they are not yet assented to, if there are things that you feel are going to be disadvantaged, it's going to be a disadvantage, start lobbying to get them not passed, or start lobbying to get your voice involved in these things so that together we shape the laws. Because at the end of the day, you as employers, you as businessmen, as businesswomen, bear the brunt of employment law. So please get involved, get engaged, and start lobbying your legislation from your MCA to your MP. Look for all of them, share your views. Law Society of Kenya, all of them are there. But for purposes of this presentation, out of all of the proposed amendments, I have selected the few that I feel would have the biggest impact on your business, and we can now move on to that. For discussions. So the first proposed amendment is on hours of work. Section 27 of the 2007 Employment Act is the one that addresses this, and it is proposed that it is amended to include Section 27, subsection 27A, which is on overtime. Now, depending on your industry, if you've got, I think the hospitality, medical, and services industry generally are moving more towards that 24-hour working schedule. So overtime is going to become a factor, but even if you work the traditional 9 to 5 in your business, overtime is still there. So the proposal is that it be catered for. And what is required of employers is that, one, you must enter an agreement with your employees that they are going to work overtime. In the absence of an agreement, it's not a good idea. So make sure, look back at your business and the way the operations have been done, and you'll be able to isolate the jobs or the functions that have routinely called for overtime. Get into agreements with them. Number two, it states that no employer shall have an employee work for more than 12 hours in any given 24-hour period. So for our people who are working over that, if this is passed, you're going to be in contravention and you may find yourself in the court. So you're going to need to be very strict in how you monitor and apply this should it come to pass, to make sure no one person works above 12 hours. But this brings a very interesting debate, because you ladies being business owners, the question would be, do you sit here? Are you part of this Employment Act? Because business owners will routinely work over 12 hours. How do we deal with them? How do we deal with our executives who we say it is their responsibility by virtue of being in leadership to work even 24 hours if need be? Those are the things that you'd need to think about. The proposal is also that when an employee works overtime in their normal working hours, the employer will pay them 1.5 times their daily rate per hour. When they work on their rest days or during public holidays, the employer will have to pay them twice their daily rate. So again, if this proposed amendment is implemented, you need to look at your budgets and start providing for overtime budgets. But to minimize that, you need to look at your work plan, your work process, your procedures, and go through that with a fine-tooth comb and bring improvements to areas that are leading to overtime. If I give you an example of manufacturing, a lot of overtime in the manufacturing industry is because of equipment downtime. So during my normal working hours, the machine was down. we have these production targets, which means I will need to work overtime and get paid. To avoid that, let us have efficient machinery, efficient processes, so that as much as possible, employees in your businesses can complete their assigned work in their assigned time, so that you don't have to pay for this. So on this side, remember, you need to budget for it, but on this other side, please also work on bringing some efficiency into your processes so that we avoid overtime altogether. There's a proposal to introduce subsection 27B, which is on night work. And the proposal is proposing to state that night work is work carried out between 10 p.m. and 6 a.m. So again, this is going to largely affect service industry, but moving forward, even manufacturing and all of these others are likely to move into the 24-hour working period. So what is the proposal saying? If you have employees who are required to work from 10 p.m. to 6 a.m., what do you need to do? Number one, you need to get into agreement with them. And I think most companies already have this, whether it is in the form of a collective bargaining agreement or in their actual employment contract. In the event you don't, anybody who is working this graveyard shift, as it's sometimes called, get into an agreement with them. That is step one. Step two, you must compensate these people who work these odd hours, and the compensation is either through a shift allowance or time off. And this time off is not part of annual leave. It is something totally different, and you'd need to agree what mode you're going to follow. Is it a shift allowance or is it time off? Whichever one you select is going to have big implications for your business. Because if you're paying a shift allowance, assuming you don't already do that, you need to again go back to your budget and make provisions for this. If you're going to give time off, on this other hand, you need to look at how you're going to rearrange your work plan, so that when these people are on time off, there's still continuity. So whichever options you look at, there are implications for it. Next, on night work, the employer, if the proposal goes through, is going to be required to have transportation available to move the employee from their place of residence to their place of work and back. That is at the beginning of the shift, so at the beginning, pick them up to take them to the place of work at the beginning of the shift. At the end of shift, have transport to take them back home. Big implications for your business again, because one, you need to look at, are you hiring, assuming you don't have a fleet of cars at your disposal, are you going to need to buy cars to be able to ferry these people? If you're not buying, are you going to hire? Or are you going to subcontract transport companies to do this ferrying for you? You need to look at all of that. All of that has got budgetary implications. What the proposal is not clear on is the number of kilometers from the place of work that is reasonable. So if my office is in CBD, Nairobi, and I live in Machakos, is it still fair for me to be dropped and picked? We're a bit silent on that in the proposals, but whichever way, even if they limit the number of kilometers, the employer is still required to provide transport. To have transport available, not to provide, because employees can still opt to self-drive, which means you need to pay them some sort of allowance. So implications if that is passed. Next, the employer, for these employees who are working these night shifts, is required to take the employee for a medical checkup prior to commencement of night work, and to periodically avail medical attention to them and let them go for medical checkups. Again, this is budget, but another way you can look at it, if you have insurance, if you're using insurance for medical cover for your employees, you can factor in these routine checks. Usually it's once a year into the insurance. So again, the impact of your business, you need to be speaking to your insurer, or if you do it in-house, you need to provide more funds to cater for all of this. Next, you need to inform the employee of any potential hazards of working these odd hours of 10 p.m. to 6 a.m. This could be things like, maybe that's the time traditionally the business has been robbed. you know, that sort of thing. But whatever hazards or security risks that may come up, you need to disclose to the employee prior to them agreeing to get on this. So a lot of things, which means you need to look at all of the safety and security risks that may happen in your business within that 10 p.m. to 6 a.m. Period, those 8 hours, document them and discuss them with the employee. So that is quite a big implication if it comes to pass, and something that is potentially very expensive when it comes to night work. The very exciting 27C is another proposal, and this is going to go down very well, particularly if you have got millennials and below, so people born from 1980 coming down. Is it coming down or coming forward? Whichever. So 81, 82, 83. This is something very nice that is being proposed. And it is the onus of the employee to put it in writing to the employer requesting for flexible working time. But there are provisions for this. There are conditions that must be met. And thankfully, the employer it is not mandatory for them to accept the request to work flexible working hours. But if the request is declined, you must give very good reasons. And I will help you come up with some of those reasons. Because if we look at working from home, because COVID, even now what we are doing, what would an employer be required to do? You need to give a laptop. You would need to have data bundles. All of these things. If you feel it is too expensive, you can decline the request for flexible working hours based on the burden of additional costs. Now, let's assume you do assent to this flexible working hours. I'm sure you probably already have some sort of working hour flexi time in your respective organizations. What I would challenge you as business owners, areas you need to look at would be, what are the key performance indicators for people who work these flexible working hours? Who supervises them? How is their performance evaluated? All of these things would need to be very well thought out as we decide whether we're going to implement it or not. But if this is assented to, it's going to be an option on the table for all of your employees. So start thinking about whether you agree with it in general or if you're not for it. If you are for it, come up with the frameworks that are going to govern flexible working time. If you're not for it, make sure it is not just your feeling or your opinion that people should be in the office. Have credible reasons why flexible time cannot work for you, whether, as I said, that is because of the burden of the additional costs, or it's going to affect your ability to meet customer needs. I'm trying to think of an example I can give for that. If it's production, sometimes you actually need to be on the factory floor for production to happen. So flexible working hours may not happen. The employer may be unable to reorganize their work, so they would decline on that. But whichever way you go, read this particular proposal on subsection 27C and see whether it can work for you. It is a good thing, but it's something you need to think through very well. Otherwise, your businesses will go down. Next, section 29, as I had said earlier, deals with maternity leave, and we've talked about what was assented to for pre-adoptive leave. However, there's a proposal to include section 29A2, which is on paternity leave. The 2007 Act does provide for paternity leave, 14 days, but now they've added a clause that it must be given, the paternity leave takes effect when a birth notification is handed over to the employer. So gone are the days when, men would just come and be like, hey, good news, pop the champagne, my wife gave birth. And we say, oh yeah, okay, you can proceed on leave. No, we need to see that birth notification. Next, compassionate leave is proposed to be introduced, and I would like to hope that most of us already have compassionate leave, because if we don't, and this is passed, it's going to come into being. And the compassionate leave entitles employees to 5 days. Yes, is it 5 days or 10 days? 5 days. Yes, it entitles the employees to up to 5 days compassionate leave when they lose a parent, a spouse, a child, or a sibling. And this 5 days is going to apply if the employee has already exhausted their annual leave entitlement. So you have an employee, they've exhausted their 21 days, which is the statutory minimum leave days, or the whatever it is in your organization, those days are exhausted. A parent, God forbid, has passed on. This person needs to go. The proposal is saying that you will release this person for up to 5 days as part of compassionate leave, and this is on full pay. Implications for your business are quite significant. Remember, this is on full pay. So this person has gone for 5 days. They've already exhausted their annual leave, which you had factored in. So who is doing their work? Because we are paying them and they are not producing for the organization. So that also has financial implications. Then something that is very close, to a lot of women, stillbirths, miscarriages. It's proposed under section 29.8 that women who are, do I say unfortunate to have endured a stillbirth or a miscarriage be entitled to 1 month leave. I will give my personal opinion on that. And if anybody has had the misfortune of having a stillbirth or a miscarriage, 1 month is really low. So as employers, particularly as women, if your business can afford it, this is just a minimum. If you can do better, I would even propose it should be 3 months, equivalent to the maternity leave. But the proposal is to have it at 1 month, which is better than what we have now, which is nothing. Okay, so that covers the maternity leave elements. We have got further proposed amendments to section 30, which covers sick leave. And remember, the Employment Act prescribes the minimum. So if in your businesses you're already doing better, then you're good, you're on track. But if you're not, these proposals can have a big impact on you. So with sick leave currently, sick leave entitlement is 7 days with full pay, and thereafter 7 days with half pay. So that is a total of 14 days. They want it to be amended to 30 days with full pay, and thereafter up to a maximum of 25 days with half pay, which means if the proposal goes through, we are looking at employees being away from office for up to 55 days on sick off. Remember, this sick off is paid sick off. Though at some point it becomes half pay, but it is still paid sick off. Again, if this is past, implications on your business are big in terms of budget, because when this person is away for 55 days, who is doing their work? That affects your workflow. And really, if someone is sick for 55 days, we are also looking at medical bills. So again, if you can negotiate with your insurer to factor some of these things in the package that they offer employees, please do. If you do it in-house, you need to relook at your budgets. So those are the proposed amendments on sick off. Further proposed amendments. Introduction of education leave. It is proposed that a maximum of 10 days education leave with full pay in a leave cycle. So in 12 months, an employee will be entitled to 10 days for education leave. What are the impacts on the business if this is passed? Again, like with all other proposed amendments, you would need to do sensitization, telling staff that this is now an option on the table. Further to that, you need to have the education leave, let me clarify, is not just for any institution, XYZ college in a back street in River Road. No, it is to credible and reputable, well-known education institutions. Those ones you will qualify. And the 10 leave days, you must also require employees to bring their exam timetable so that you can confirm the day of the exam corresponds with the applied leave day. Yeah, so it's clear. So it is 10 days. It must be to a reputable institution, and employees are required to attach exam timetable so that the leave administrator can compare the education leave applied for versus the timetable. Next, amendments to section 44, which is on summary dismissal. This is a big one. This is a very big one, and really most disputes will come from how we separate with our employees. So the 2007 Act already had provisions for how to deal with summary dismissal, but there's a proposal to include 3A, subsection 3A, which gives requirements of the employer before acting. So what are these requirements that the proposal is saying? They are saying that, one, in the event of summary dismissal, or when a business owner is contemplating dismissing somebody, one, you are required to put it in writing, clearly stating the what? The crime. Clearly stating the nature of the charge against the employee. So what exactly did they do? And you give it in detail. So it's not that you stole. It's that you stole item X. It is suspected that you stole item X on this date, at this time, with, really document what the crime is, the alleged crime is. Number two, an employer must give the employee the right of response, which means usually you will hold a disciplinary committee of some sort where the accusation is made and the employee has the right of reply. Three, you must communicate the output of that disciplinary committee meeting to the employee and give them the right to appeal. That is what 3A is proposing. 3B states that consequences to employer gives the consequences to the employer for not adhering to those three proposals of state what the charge is, give them a right of response, communicate the final decision, give them the right of appeal. Should the employer fail to do those four things, then it counts as unfair dismissal. And unfair dismissal is unfair for both the employer and the employee, because the employer wanted to get rid of this person, but because they'd had an erroneous procedure, this individual can actually be reinstated. So a person that you didn't want. So what are the implications for your business? Your records must be perfect. Your documentation, nothing verbal. If there's verbal, follow it up with the word of mouth. Clearly document actions done by employees, actions done by the employer, have minutes for any disciplinary hearing that is held, have copies of all correspondences with the staff, either communicating the decision, hold the appeal committee meeting if need be, do everything correct, so that if you are unfortunate enough as an employer to end up at the Employment and Labor Relations Court, your documentation will be your saving grace, because it will demonstrate due process was followed. In the absence of that, you're going to be facing unfair dismissal charge, which can, it's reinstatement, or you may even be forced to compensate the employee. So please have your documentation of the process followed top-notch. Next, we have got service or gratuity pay. It's proposed to be included in the Employment Act. And it is proposed that we pay 15 days for every year worked. I believe this is fairly common practice in most businesses and organizations. So it's not really something new, but it's good that now there's a proposal to actually embed it in the Employment Act. Ramifications for your business. If you have not factored 15 days pay for every year worked, you need to start factoring that in your budget, particularly for your contract employees. And God forbid you reach a point of needing to have redundancies. All of this is money. Every single proposal has got a money aspect to it, so you need to think about it. Next, we've got suspension. It's proposed that the Act is amended to limit the suspension period to 14 days with full pay to allow for investigations. Now, this is also another dicey one. Let's start with, it requires the employer to be very swift in the investigations and very conclusive, collect all the evidence within 14 days. My issue with this proposal is the practicality of it. For minor misdemeanors, 14 days should really be sufficient. But for major crimes that have been committed by an employee to the employer, you may need to conduct forensic audits. You may need to get specialized security agencies, for example, DCI, to come in and, bolster your investigation. There are so many other things. The 14-day period is very, very tight. But if it is passed, what I will say, your investigation team, you need to know, are you going to be doing investigations in-house? If not, are you going to hire third parties to do it? What is the documentation? Because this turnaround time, it is very, very short. We are almost there, guys. We are almost there. Next, there is a proposal to repeal Section 48, which in the current Employment Act, the current Employment Act prohibits an advocate from representing a party in the proceedings before a labor office. Remember, the labor office are part of the institutions we talked about earlier that form part of the larger labor laws. It is proposed that this is repealed and substituted with a new section that allows for representation by an advocate. This is a good thing. This is a good thing because sometimes you're not able to represent yourself very well and you get caught up on legal loopholes. But what is the implication for this? You need to have good lawyers on speed dial or on your panels, and not just lawyers, preferably lawyers who are conversant with the labor laws to represent you as an employer. Your employees, if they're in union, they will have their union officials, and they are very good at representation. So this implication for your business, you need to have lawyers if you don't have any in-house labor lawyers who you may not need to enter a contract, but at least identify the ones you would be willing to work with and who are willing to work with you, so that if push comes to shove, you have got legal representation. Next, amendments to Section 74, which is the records to be kept by an employer. So this is about integrity. This is about fair play. This is about information systems and how we manage our employees' records. So what is the proposal saying? It requires employers to get written consent from employees to collect information from third parties. It prohibits the use of polygraphs, truth verification equipment, or any other similar testing procedure in the context of employment. So if you're using polygraphs or any of these other pre-employment tests, if this is passed, that is gone, it's prohibited. Next, gone are the days when you can just write to a former employer for their opinion on this prospective employer. You will need to get their written consent on that. This is a good thing because data management, in the past, because I've done recruitment, and you find the former employers sometimes write terrible letters to the point that you actually remove this person from consideration from a job. Whereas, and you never have engaged the employee to get their side of the story of what exactly happened in your former employer. So this employer has written a very damaging letter and basically says, do not employ person X. And usually we have been influenced by that. But now this is saying we need the consent, and we will also need to disclose the information to the employees so that they have a right of reply. It also means you will not have employee files which have details that nobody else has. I need to know what is in my file as your employee, and so on and so forth. So a lot of transparency is being brought into records that employer keeps on an individual. So I hope I have been true to my time. Almost. I say a very big thank you. Those are the major labor laws. I hope our objectives have been achieved. I have also articulated what has been amended and the proposed amendments and the impact that it's likely to have on your company. So at this point, I will stop sharing. Yes, I have stopped sharing and open it up if there are any questions or comments. Oh, I'm seeing there's something in the chat. Susan, is there anything?
Yes, there are a number of questions on the chat. And just before we get into that, I love the fact that as you're going through the proposed amendments, that the ones that haven't been passed, you've repeated the fact that each of them is going to have a financial implication for the businesses. I think that is quite crucial for everyone to know that, you need to start preparing and amending as you've highlighted in most of them. Now, I'm just curious, Sarah, especially now going back to the one which was signed on the pre-adoption, the leave for adoption. And, in Kenya, okay, not just in Kenya, let's just say as humans, we tend to sometimes start abusing something that we've been given. In this case, so now you're allowed to take leave to go process the adoption and all that. But I think what I noticed, if I read properly, was that the document did not specify like how many times in a year someone can do that. Because I was thinking of a situation where someone does that, takes the leave, and then maybe they come back and claim, oh, it didn't go through, I didn't succeed. They wait for a few months, go back. And
Yeah.
so I think there's, for me, I'm thinking maybe that could be a challenge. I don't know how that can be solved. Or is there a way that that can be dealt with if it's not indicated in the amendment itself?
Yes, yes, there's a way. Remember when I was on that part, I said you need to update your procedures. So a requirement is we should see the court order, because this is a court process. It's not the days when you take your, I don't know, your sister's child and have adopted this child now. So the employer will have to clearly, the business owners will have to clearly state what the requirements are for you to qualify. And you can only do that once every 2 years. So you cannot make a hobby of adopting children in the name of getting leave once every 2 years.
True, that's very, very true. And also in the same topic on adoption, there's a question that states, what is the position of the adoptive leave when it comes to the fathers?
Silent.
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 Silent, nothing. Okay.
Silent,
So
but yes, for now, but you can still develop. It's silent, so really you don't need to provide for it. That's what I would say. However, if you can be a good employer, I don't know, we can apply a pro rata calculation, because for 3 months maternity leave, you get 2 weeks paternity leave. So now for 1 month pre-adoptive leave, what is the equivalent? I think it might be 1 day or 2 days. I don't know. But it is silent on how the father features in the adoption.
Okay. All right. Thank you for that. Then I have a pretty long question from Saum. So she's asking if you could briefly touch on the non-compete clause, the non-disclosure clause, the employee's rights after their death, sick leave amendments, statutory educational leave, and gratuity on termination. Okay, so you don't have to cover on all those. Maybe you can pick 2 or 3 items and just clarify a bit on that.
All right, I think we actually touched most of them. We discussed the sick leave, we discussed education, all of that. But on the non-compete, so that is basically, I acquire a skill or a competence in the course of my work that makes me an expert in this. I cannot, let me give a tangible example, pharmaceutical industry. So you go for training on how to make a particular medicine, for example. You cannot now take that knowledge and move to a competing pharmaceutical company to produce the same drug. That is what that is, but that should be dealt under contract law. But with this requirement for the last one that I talked about on information by what the employer can hold on the employee, that will cover it. But for the non-compete, that is really contract law, and you should refer more to that. But usually it is bound by time. So depending on how significant the investment was, you'll be bonded for X period of time. And even if you leave, you will find you cannot use that same knowledge for the benefit of a competing organization for a further period of time. I hope that answers the question.
Yes, I hope so too. But in case Saomi, if you need any other clarifications on anything you've stated, you can just indicate that on the chat box. And then her other question is that with the current state of the global economy, we know that most businesses are struggling. So what does the law say about putting employees on short-term contracts, like for 6 months, as a way of risk mitigation for a small business owner?
Okay, I can answer that question on 2 parts. So for a new employee joining your organization, no problem. They can be on a 6-month contract. That is fine. If she's asking about existing employees, I don't know if that's what the question is, whether existing employees can be converted to 6-month contracts. That is not so clear, because you would need to see what is the current agreement. What are they under? Because you cannot switch terms midway. the employee would also be required to agree to that proposal. So if they were on permanent and pensionable basis, and you now want to switch them to 6 months, that can be a bit of a challenge on the part of the employer.
Right, right.
But for new ones, for sure, do that. And for any others that you have in employment, what you can do, as the contracts come to a close, shorten it. But remember, in all places, this is about that balance of power and industrial harmony. Communicate, give the reasons why you're doing that. Declare the financial position of the organization. Like, look, guys, we can't afford. The other option, if we don't go this way, is actually is to terminate or for the organization to wind up, which is not desirable for anybody. So that flexibility will be there, but I would advise apply it to new employees, or when contracts of current employees end, let this be the new offer.
Right, right. So I hope that your question has been answered clearly. And I like those some comments and observations as you're talking about the proposals, especially where the maternity leave and the sick leaves are concerned. There's a comment about someone who actually went through a miscarriage, and she believes that the 1 month is enough, is sufficient.
Oh,
Because yeah, in her opinion, she says that it's easier to deal with the loss by being busy at work as opposed to staying at home for a long period of money. That's if there are no complications after probably a miscarriage. And yes, and a comment also on the same support for the 1 month, where Rose says that it would, however, be in order to find out what's reasonable, then give the flexibility to return to work earlier. So that's another opinion on the same. And also Elizabeth supports the same, the 1 month. Yes.
Good. So
Right.
when that proposal goes, we will support it if it's assented to.
Oh yeah, for sure. Definitely, definitely. So we do not have any other comments or questions on the chat box at the moment. I don't know if Rose, do you have any question or comment before we proceed to something else?
Just wondering if we've got any on Facebook, Susan?
No, we don't have any on
We
Facebook.
don't have
No,
any.
we don't have. Yeah.
We don't have any on Facebook. So at the moment, no further comments. I think it's been very, very comprehensive, and maybe Elizabeth will tell us more in her closing remarks. But
Yes.
yeah, very, really informative, Sarah.
Thank you.
So just very briefly, appreciating what you've done for us today. Yeah.
Thank you.
Susan.
Yes. Yes. Yeah. So we've gotten another question, which states, you've been asked to comment on the employee rights after their death.
Okay. So when the employee dies, any dues or benefits, so let's say salary, terminal dues, all of that goes to the beneficiaries, the nominated beneficiaries. So that means for the organization, again, we're back to documentation. You would need to know who is number 1 beneficiary, number 2, to what percentages, so that any final dues, any dues that should have gone to the employee while they're alive, at their death, pass on to the benefactors.
All right. Thank you for clarifying that. So since we do not have any other questions for now, I would before we actually get into the closing remarks, I would like to just quickly invite everyone who's whether you're participating on Zoom or on Facebook. As Rose mentioned, we do have a number of programs. Some are going on and some are coming up. I would like to invite all the participants to the same. So please allow me to just share my screen really fast. There we go. So next week on Wednesday, we're going to continue with our weekly discussions, and the topic is the role of clearing and forwarding in international trade. And our guest, who's actually a participant today, is Saum Siraj, who's the Managing Director of Duke Stop Freight Logistics. Some time back, we talked about being export ready. I don't know if some of you attended. So this is a continuation of the same discussion. So please join us. And this one is very, very exciting because this is an initiative by the Commonwealth Business Women Network in Kenya. It's the marketplace, and I think I've shared the link on the chat box. So this is an opportunity for women entrepreneurs and also the youth to come in, register for free, and showcase their products or services. Right now, we have about 45 categories, everything from beauty, from interior design, HR. So there's so many categories that are represented. So if you're interested, please register for free. It was launched on the 21st of April. And most important, please invite all the women entrepreneurs and the girls that you know who have their small businesses, because they will get to actually connect, collaborate, and do commerce with other entrepreneurs within the wider Commonwealth. So it is quite big. It's ongoing. So please, please support. Not forgetting the inaugural Commonwealth Women's Entrepreneurship Summit, which is next week on the 19th and the 20th of May. Joining the summit is also free of charge. And this one is convened, as you see at the bottom, we have the Commonwealth Business Women Network, International, we have the UK government, very, very big organization supporting. And to be able to know more about all this, follow us on Facebook, Commonwealth Business Women Kenya, visit our website, cbwnkenya.org, or even follow us on Twitter. You'll find all the information and all the links to be able to register and join in. Right. So at this juncture, is it juncture or juncture? Sorry, I never say it properly. I would like to invite another member of the Programs and Trainings Committee who's going to give us just a highlight of what we've listened to today, what we have learned, and also to give the closing remarks. Karibu sana Mweni Deleva.
Thank you very much, Susan. Thank you very, very much for being the MC of this program, of this today's forum and many other forums that we have participated. And thank you, Sarah, for this very important topic, which is critical to us to understand individually and as employers. Thank you, members and non-members of CBWN Kenya chapter for attending today's forum. We look forward to having you again, and please invite your friends and other people, ladies, to be able to join the Wednesday forums. So, as employers, we have seen how important it is to keep tabs with the current labor law requirements, the amendments that are ongoing. We have been given highlight on those amendments that are currently yet to be approved or passed. So it is for us to work on our policies and review them and amend our policies to be in line with processes and or legal requirements. Currently, or lately, you've seen employees being more aware of their labor rights, their labor legal rights than they were before. So it is for us to incorporate this into our policy so that we avoid getting these legal matters at court, because we've seen many employers, including the list of employees that you can, there is no bigger, there is no list, but even the very casual employees that we have, it is key for us to just get to put into consideration these legal requirements. So thank you very much for the forum. And I think we have quite a bit to carry and take home and learn and implement in our organizations, both from policy perspective and also budgetary perspective. So we really appreciate this. Thank you for coming and have a good week. See you next week. Back to you, Susan. Thank you.
Thank you so much, Mweni, and especially for highlighting the fact that we always have to be compliant in our businesses, following all the rules and the regulations in place. This is very, very important. So once again, thank you everyone for joining in. I hope to see you all again next week on Wednesday at 1 p.m. as we get to hear about the role of clearing and forwarding in international trade. Also, join our summit. As I mentioned, it's next week. All the links are on our website, or if you follow us on Facebook, you'll find all the details. And please, please, please encourage and invite all the entrepreneurs you know, and especially the young girls in your chamas, in your WhatsApp groups, in your church. And yeah, seriously, they need to come in and join in the e-marketplace. This is such an opportunity for them to be able to showcase their products or services in the wider Commonwealth, and they'll get to connect with all the other people out there. It's a big one. It's a big one. So please invite them. And yes, I will continue to remind you, keep safe, wash your hands, sanitize, keep social distance, get vaccinated. Yeah, let's continue to stay safe. Even on such cold days, they're still beautiful days. And I hope to see you all next week. I wish you all a very, very beautiful day. Bye, everyone.
Thank you.
Thank you.